court is now in session. The Honorable Judge George C. Ferris presiding. You may be seated.
Ready to resume?
Yes, sir.
Okay. Let me call your first witness. Unless there's anything preliminary we need to discuss.
We're ready to all the designations were taken care of.
Oh,
Well, I think we need to sort out the designations. I mean, Alyssa submitted hers, and then during the break, we agreed that one of the deposition designations would be revised to eliminate some hearsay. But other than that, with respect to the deposition testimony that the moving parties have designated, we don't have any objection. I would just, do you have a copy of the deposition designation up there? Or?
I don't think so.
Okay.
I'll have to revise it to reflect the change that we agreed to, and I'll send it back to the court.
Okay.
But we're all set.
All right.
So the petitioner, Russ?
Yes.
Your Honor, in the first order of business, the respondents, plaintiffs, will make a motion for a directed finding that the burden of proof has not been met by the petitioner with regard to establishing the necessary elements in order to obtain a preliminary injunction. The elements, as I'm sure the court is aware, are that the movement's remedies at law must be inadequate, and there must be irreparable harm pending resolution of the substantive action. We've had testimony in this case that's been submitted. The only time irreparable harm was mentioned, I think, was by Dr. Stummer. However, it was also mentioned in that same answer that there would be a loss of current and future income established through Dr. Stummer's cross-examination, that when patients are seen, codes are entered by the physicians and then submitted to the billing company, that those codes are subject to determining what the reimbursement is for the various practices. In other words, if it's determined by this court at the final hearing that there is an issue and that somehow the covenants do survive, that damages would be calculable. Our physicians have, like all others in all practices, such as Francisca does and just as medical specialist does, the billing and collection service and system, and they know exactly what patients were seen, what codes were charged, and what money was earned. If there are different reimbursable rates, I think which Dr. Stummer testified to also, certain groups or hospitals or practices will have different reimbursable rates depending on the insurance carrier, Medicaid, Medicare, and the like, and that those amounts are readily ascertainable. And that in fact these institutions and practices make it their business to know exactly how much money they earn off certain charges, codes, and patient visits, or procedures that are done. So as to the first prong of obtaining a preliminary injunction, what has to be shown, we don't think that burden has been carried. They also have to establish the movement that they have a reasonable likelihood of success at trial by establishing a prima facie case. We do not believe that that has been done based on the fact that they have no, when I say they, I mean medical specialist who's the movement here, has no continuing interest that is legitimate that can be protected. We've had testimony from Dr. Stummer that as of October 1st, 2012, he has sold substantially all of the assets, save life insurance policies, some accounts receivable due, and a restricted ability to use the name medical specialist in PC, subject to a covenant not to compete with Franciscan Alliance, and that trying to, we think the evidence is established, trying to then cobble together an organization and entering into the May 22nd agreement 2 days before the summary judgment is due is not enough to create a legitimate business interest that requires protection of the non-compete covenants. I do not think they've been able to establish that they can make that prima facie case. That's the second prong. The third prong, the law requires, in order to establish the grounds for a preliminary injunction, is that the threatened injury to the movement outweighs the potential harm to the non-movement resulting from the granting of the injunction. From the position of medical specialist in PC, we're really talking about only money. From the position of the respondents in this case, we're talking about the careers of 4 hardworking doctors who've taken great time and care to establish their practices. We're talking about their families. We're talking about moving offices and eliminating investments in offices. In other words, they're out. If an injunction, preliminary injunction issued before a final ruling is made in the case, they would be out flat, and medical specialists would continue to survive and would not have to do anything, would not really suffer any harm that's not calculable by money. And as to the 4th prong, that is the public interest would not be disturbed if a preliminary injunction were issued. If a preliminary injunction were issued, my clients, the 4 plaintiffs, as I've said previously, would be out of business. Okay, how about their patients? The number in the thousands. They now could suffer adverse health consequences. I know that if an injunction is not issued, it will not suffer because of someone's inability to find a doctor or to see them quickly, or that doctor will know and understand their history without having to start over from scratch. The public interest would be disturbed in the event that the preliminary injunction were issued. The movement, Your Honor, in this case, Medical Specialists Inc. PC, has to prove each of the requirements to obtain a preliminary injunction. It's Roberts Hair Designers Inc. versus Pearson, 780 Northeast 2nd, 858, Indiana Court of Appeals, 2002. If the evidence fails on any one of the 4 prongs that we just stated, then the preliminary injunction cannot issue. It's also been stated that the court's power to issue an injunction should be used sparingly, and such relief should not be granted, except in rare instances in which the laws and facts are clearly in the moving party's favor. Leads me to a point, Your Honor, when it talks about the law and the facts being in the moving party's favor. I think it was Daniel Patrick Moynihan that once stated, people are entitled to their opinions. They are not entitled to their own facts. And what we have here is the finding of the fact pattern. We believe the evidence has shown this clearly, and the court's record on summary judgment has shown this clearly, that the May 22nd agreement, which we've talked about at some length, was, quite frankly, cobbled together in order to avoid the potential pitfalls of this case. If you find that the facts, when you apply the law to them, do not add up correctly, you better go out and find yourself some new facts. And that resulting attempt to do that is the May 22nd agreement that suddenly, and 9 months after the fact, 8.5 months after the sale, says, okay, medical specialists, you can compete with Franciscan Alliance, who we just paid $21 million to. Go ahead and put your organization back together, because Franciscan, a stranger to my clients, whom they did not contract with for employment, decides that they want to protect their goodwill. Well, they know they can't enforce in a black letter law that a purchasing party in an asset purchase cannot enforce covenants against someone who had an employment agreement that did not consent to have that third party, that eventual seller or that eventual purchaser, enforce those employment agreements. As of October 1st, 2012, the date the sale took place, and the plaintiffs were aware of the sale. Dr. Leos, which Dr. Stemmer stated was on the board of directors of Medical Specialists Inc. PC, was privy to the asset purchase and was able to see in it all the contracts, all the assets, everything medical specialists owned in medical practice was gone and was being sold as of October 1st, 2012. It's as of that date they have to decide what we're going to do, where we're going to go, and how we're going to handle it. Medical specialists as it existed, 60 plus medical professionals, $60 million a year in annual revenue, equipment, supplies, software, hardware, computers, everything, chairs, desks, gone. Leasehold improvements, gone. Pulled out from under them. Now to go back on May 22nd and say, gotcha. Maybe that has merit, maybe it doesn't. What it doesn't do is support the issuance of a preliminary injunction. And until there's a final hearing on both our complaint for declaratory and what would be certainly a movement for a final hearing on the final injunction in this case, the permit. Thank you, Your Honor.
Okay. Mr. Johnson?
Each of the contracts admitted into evidence into which the plaintiffs enter provide for multiple restrictive covenants. Each of those plaintiffs have violated the restrictive covenants. They practice medicine within 10 miles of locations at which they practice medicine for medical specialists. Doctors Laus, Sethi, and Patel have formed a company called Pulmonary and Allergy Associates, which maintains an office on 45th in Munster, just down the street from 761 45th, where they practice as members of medical specialists. There is a 2-year, 10-mile covenant. They have violated that. They have an obligation to resign from a hospital when they terminate their employment with medical specialists. They have failed to do so and, in fact, continue to practice. That applies to the hospital-based practices, specifically of Dr. Laus, Sethi, and Dr. Atasi. They have a covenant not to solicit patients that is included within each of their employment agreements. Yet, during the period of time while they were still employed by medical specialists, they prepared lists of patients who they were seeing at medical specialists, and then began to call and solicit those patients directly once they established their new practice. The new practice, Pulmonary and Allergy Associates, is made up of physicians from medical specialists who have violated the temporal and geographical restrictions of their covenant, made up of physicians who have failed to resign their hospital privileges, made up of employees who used to work for medical specialists and now work there, and populated by patients of medical specialists, many of whom they have directly solicited. All of those things are in violation of the covenants contained within their employment agreements. Now, who did they have an employment agreement with? By the insistence of their counsel, in a letter that is now admitted into evidence, counsel insisted that they be employed by medical specialists. So when someone talks about the asset sale agreement, although the document which you will have in front of you contains several pages of excluded assets, the simple fact of the matter is that these plaintiffs insisted that their employer remain medical specialists. So they took their paychecks, received their bonuses from medical specialists from October 1st, 2012 until they terminated their agreements on June 30th, 2013, while at the same time violated every restrictive covenant in those employment agreements. It's not a question of not violating some. In this case, there's evidence that they violated every restrictive covenant. And what does the agreement provide? The agreement provides, in clear language with regard to each of those restrictive covenants, that the covenant is reasonable and that it may be enforced by the issuance of an injunction. So they continue to work for an employer, knowing full well that there are enforceable covenants that are enforced by injunction, and they take all the benefits of that employment, and then they violate all of the covenants. Now, to say that there isn't a probability of success on the merits, we've proven that those covenants have been violated. There is no dispute with regard to that. Now, have we suffered irreparable injury? The agreements provide that we are entitled to injunctive relief because the magnitude of that injury is serious and substantial and can never be redressed. Because now we have a competitive injury as they've gone out and competed with medical specialists after promising and agreeing that they would not. And that promise not to compete survives for 2 years afterwards. The fact that damages might be available at some later time doesn't preclude the issuance of the injunction. Does anybody really think we're ever going to be able to recover the magnitude of the losses sustained because of the competitive injury which medical specialists is now sustaining because of their violations? Of course not. That's the reason they agreed to the issuance of the injunction in the very agreements which are in evidence. Now, when they talk about the damage to them, we've been through this before in Raymundo. The Supreme Court had this whole issue before it. And you recall Raymundo, which was at 449 Northeast 2nd back in 1983. Raymundo said there's a damage to the public interest by precluding me from practicing medicine. Just as there is a damage to the public interest, the plaintiffs tell us, by precluding them from the practice of medicine. And what does the Supreme Court say? You know what? There's a bigger issue than that, Dr. Raymundo. That's the enforcement of contracts. And we're going to enforce contracts among mature adults. We believe in the freedom of contract. That is the overarching public interest that's involved in a case like this. We went through that in the summary judgment hearing. And then when we deal with Sluian, we have the same sort of argument in the Sluian case. And you recall that Sluian was able to convince a trial court that the injunction should not issue. And the Court of Appeals said, you've got to be kidding. There is no public interest exception here. The contract containing the same covenants, because it involves the same employer, was enforceable against him. And when Sluian sued his lawyers for legal malpractice, in the second case, the Court of Appeals said, you aren't entitled to recover against your lawyers because your claim that your covenant wasn't enforceable because the public interest was lousy. There is no supportable argument with regard to that. Now, the whole issue that counsel really wants to talk about is, let's talk about medical specialists. And the May 22nd agreement isn't really an agreement at all. It is just an agreement to try to pull the wool over the court. Nevertheless, you hear Dr. Stemmer testify about the fact that there are a number of hospitals with whom medical specialists maintains medical directorship agreements. Those hospitals, St. Catherine's, Community Hospital in Munster, and St. Mary's, include contracts for respiratory services, for wound and ostotomy services, and for infection control services. If medical specialists continues to survive as an entity that employs physicians who are not FA physicians when they render that care, the public's interest is served by having the experienced medical specialist physicians offer those services, provide those services. And that's the reason that we have the letters of intent, and that's the reason Dr. Chi has been employed. to continue to provide those services. So what we have is an entity, as Dr. Stemmer testified, after October 1st, 2012, that employed 7 physicians, including these 4, at their own insistence, who continue to operate, to bill for, and to pay those physicians. When those physicians announce their intention to leave, replacement physicians are in the process of being recruited to replace them. Why are they being replaced? Because it's considered to be beneficial to all within the community to have non-FA affiliated medical specialist physicians rendering care at non-FA hospitals and continuing to provide the service under the directorship agreements. Now that is the interest that's been articulated, about which the plaintiffs believe there is no basis. But that's the evidence so far, and that's the only evidence you're ever going to hear with regard to that. And that's why we have the letters of intent. That's the reason we have the May 22nd agreement, and that's the reason we have the partial waiver of the restrictive covenant, to make absolutely sure that there's no issue with regard to the ability of those physicians to provide those services. So what we have is the probability of success on the merits. They violated their contracts, and we have a right to enforce those contracts. They took our money, and they violated the covenants. That's our probability of success on the merits. It's uncontested. We have no adequate remedy at law because no amount of damages, because of the difficulty of estimating them and the problems of collecting them, would allow us to move forward in simply a damage issue. We have to have the right to get the injunction, and that's the reason the contract specifically provides for the issuance of an injunction, and the fact that all of these covenants are regarded as reasonable by the contracting parties. There is no balance of the hardships, which says that the party who enters into the contract, such as these plaintiffs, can take the advantage of the contract, have their practices built up over time because of their association with medical specialists, and then turn around and say, if you put me out of business by doing this, it will bring about hardship. When the Court of Appeals had before the case involving the South Bend Clinic, in which the clinic sought to enforce a covenant not to compete, and the St. Joe trial court said, we're not going to enforce it. In reversing that decision, in Harris versus Primes, 450 Northeastern 2nd, 8085, in 1983, the Court of Appeals says the members of the clinic who spent years and money developing the South Bend Clinic had a legitimate and realistic desire to protect not only their investment in Dr. Primus, who came and went, but also to restrict her competition with them once she left the clinic. They have a protectable interest in enforcing the covenant against Dr. Primus. All you have to do is change the names to medical specialists and change Dr. Primus' names to the names of the plaintiffs. Additionally, as the court tells us in another case where they reversed the denial of relief at the trial court level, involving Chavarel versus Magnenti, which is at 836 Northeastern 2nd, 432. It is 22 years after Harris. And what's the issuance? What's the basis for the issuance? The presence of Dr. Magante, who had no ties to Indiana before the employer recruited him, in the Lafayette area is a direct result of the employer's efforts to ensure a successful practice in Lafayette. The employer has demonstrated that it has a legitimate interest worthy of protection by the covenant not to compete. Again, simply substitute the names of the plaintiffs and the names of medical specialists with regard to this, and you reach the very same conclusion. Now, finally, with regard to the public interest, there is no public interest issue here because the freedom of contract prevails. The Supreme Court has told us that since 1983. So, for all those reasons, not only have we made a prima facie case, we've demonstrated much more than that, and we are entitled to the issuance of a preliminary injunction in this case.
Your Honor, in response, I want to first point out not a word that Your Honor just heard dealt with harm to the public, dealt with the public interest. One of the 4 prongs that must be shown, must be proved by preponderance of the evidence in order for a preliminary injunction to issue. Not addressed, because the harm to the patients of my doctors and no harm to any patients of medical specialists to the extent that they have any. There's been testimony they don't have one doctor working. As of yesterday, when Dr. Stemmer was on the stand under an employment agreement as a clinician with medical specialists in DC. There just isn't one. October 1st, supposedly Dr. Chi is going to come here, and she's going to be number 1. We have agreements to agree with another doctor or 2 doctors. Letter of intent. An agreement to agree is legally nothing. It is an unenforceable agreement with any stretch of the imagination. Therefore, there is no interest that they have to protect. None of the cases that Mr. Jensen cited, and it appears that citing the Raimundo case, which I know well, Dr. Raimundo happens to live 2 houses down from me growing up, and I used to shovel his driveway. They know all about it. None of those cases involved an asset sale. Not one of the cases cited involved a group of doctors who were working for a very large practice that all of the assets of the company they had signed up to work with and signed up for a restrictive covenant with, all those assets are pulled away. They're gone. If you're on a carpet, the carpet got dragged out from underneath them and left them standing on rocks. Mr. Jensen said it's difficult, it would be difficult to calculate damages because of their magnitude. Just because it may be a lot doesn't mean it's incalculable. The people here, Dr. Stemmer, has run a highly successful, what was a highly valuable, to the tune of $21 million at minimum, medical practice, has the facilities to calculate those damages. He's also the president of Franciscan Medical Specialists, whose business it is to calculate what you earn from procedures, patient visits, rounding in hospitals. These things are not beyond the realm of calculation. In fact, I submit they're quite easy to calculate. We're only talking about money. We heard Mr. Jensen state that the medical directorships that medical specialists maintain are of a vital nature. None of these 4 doctors is a medical director. That is an administrative position. They are not clinicians under their medical director agreement, seeing patients in their office every day and job at hospital. Not one of these 4 maintains any of those positions. It's certainly not a competition with the agreements that medical specialist claims to still have. Also went through with Dr. Stemmer while he was on the witness stand. Schedule 1.1c of the asset purchase agreement. Every single medical directorship, according to the asset purchase agreement, to which the plaintiffs were privy, stated that all those medical directorships had been sold to Franciscan. Lock, stock, and barrel. Taking them back at a later date and saying we had an agreement to agree that we would do this later affects my client's rights. All they were made aware of in the asset purchase agreement is that all those are sold. Medical specialist has nothing left at the end of that day of October 1st, 2012. The fact that they want to put that back together and say, well, we need to keep them in medical specialist's name because the competing hospitals won't like Franciscan employed physicians for having contracts with Franciscan because they compete. Doesn't create a protectable interest against my clinician physicians in any event. But, Your Honor, if any one prong of the 4-prong test fails, in the preliminary state of an injunction, in a case for injunctive relief, the preliminary injunction must fail. I suspect, as another factor that is important, as to the final and as to our trial and our original complaint, we're the plaintiffs in this case, for a declaratory judgment as to what the rights of the parties are, can be had in relatively short order. I know the court's calendar is not funny and there's a lot of stuff going on, and a lot of trials to be had. Keep in mind as well, the evidence and the record both reflect that the doctors went to work openly, conspicuously on July 1st, 2013. The motion for, or the petition for a preliminary injunction wasn't filed till early August. A month went by. Now it's a 3 or 4 page filing with a 2-page affidavit attached to it. Not something that's supposed to put together. Required great consternation. Didn't seem that important at that time, but now there's this exigency that we have to do this preliminarily rather than at the final stage of this case, which is not upon us yet. I think it's disingenuous. I think it's wrong. I do not think that all 4 of those elements, I don't think any of them can be proven. Certainly as to irreparable harm has not been shown. And nothing was said about the harm to the public interest. Thank you, Judge.
Okay. All right, court, this time I'm going to deny the motion to proceed with the remainder of the evidence.
Okay. We'll call Dr. Patel.